Hello, everyone, and welcome to the webinar today. My name is Alexandra Alvarado, and I'm the Director of Education here at the American Apartment Owners Association. Thank you so much for joining us. We are very excited to have with us an expert attorney on all things utility billing and fair housing. And we do have quite a few questions. In fact, you all have already submitted over 40 questions to us in advance. And so we have plenty of time here to go over them. And I am really looking forward to learning as well some new things about utility billing and the legal regulations around them. But before we start with that, I just want to send out a few reminders. One is we are recording this webinar as usual, and we will be sending it to you tomorrow afternoon. So please keep an eye out for that. You'll also get a copy of the slides, the PowerPoint, and we'll send you over the contact information for our speakers today if you did want to get in touch with any very specific questions, or if we're not able to get to all the questions today, you can also expect somebody to be reaching out to you with an answer. So please put your questions in the question box if you do have any throughout the presentation, not the chat. The question box area helps us to keep those questions a little bit more organized. So with that said, we want to welcome today our speakers. We have with us Annette Gallagher, who's the Director of Content at Livable. And we have John List, our attorney today from Lubin Olson and Domsky. Sorry if I butchered that name. I'll let them introduce themselves just a little bit more in depth, and then they'll give you a brief overview of what Livable does and also a few little basics about utility billing in general, and then we'll open it up for questions. So with that said, thank you for joining, and I'll hand it off to you all to get started.
Okay, well, as Alexandra said, my name is Annette Gallagher, and I'm the Director of Content for Livable, and joined today by John. So I'm just going to tell you real quickly, and I want to apologize ahead of time. I see, for example, yeah, my slide took a little while to load there. I'm in South Florida, and we have had torrential rain the last few days. My internet has been a little wonky. I am hopeful that it will be fine. If there is a problem, I will simply turn my video off, and that should free up and make it all fine. But in the meantime, I just want to put that out there right away that there might be a little bit of a glitch, but we'll get through it. So I've been the Director of Content at Livable for almost 2 years, and I have more than 8 years of experience creating educational content about all things related to property management. So that is why I'm the one speaking to you today. And education is part of my passion. I'm also an adjunct professor at the University of Miami, which is my alma mater. Go Canes! And love helping make the world a better place, which is a key part of Livable's mission. So, John, I'm going to hand it off to you.
Yeah, I want to give a brief introduction. My name is John List. It's pronounced Niewiadomski. It was an interesting thing to learn when I joined the firm. But I am an attorney in California, where we have a lot of regulations about landlords and tenants and how we can charge them and pass through costs, etc. I've been practicing landlord-tenant law for the past 10 plus years, that whole time advising clients on ratio utility billing, or RUBS. And my practice also includes all aspects of owning, operating, buying, selling, financing, both market rate and affordable housing. So today, I'm just going to give you a kind of general legal background to how RUBS works, how you can do it, and we'll get as specific as we can, but here's my legal disclaimer. I'm only giving general information. We're not creating any kind of attorney-client privilege here. And I'll just be answering general questions. If you have specific questions, if you have a specific issue with a tenant that you need help with, be sure to call your local attorney. Livable has a good basis for, a good database of people that they know and can advise both on their operations, but also they can refer you out as necessary depending on your situation. I'd also just like to take this opportunity to thank both Livable and AAOA for inviting me to be part of this, and I hope to answer as many questions of the dozens that have been received so far.
All right, so moving on, just to talk very quickly about what ratio utility billing is. Some of you may already be familiar with this idea. At Livable, we absolutely believe that if you can tie a tenant's consumption to um, their wallet, they will use less. We've all been that person at a hotel, right? Where we crank the AC down to 62 and take a 30-minute hot shower because we're not paying the bill. We're not seeing how much that actually costs. And when utilities are included with rent, some tenants also adopt that same mindset. They don't see that the consequences of use directly, and so they use more than they would. There are some studies that show that simply informing people of their consumption causes them to use up to 15% less almost immediately. So that's a big driving force of what Livable does. We want to help drive conservation and housing provider profitability by holding tenants accountable for their utility use. Cost of utilities is going up. It is only going to get worse. I saw an article a few weeks ago that the United States is looking at roughly $1 trillion in costs for water infrastructure in the next 10 years. $1 trillion. That will be passed on through water bills. Let's get that very clear right now. Here in Broward County, South Florida, where I live, we're talking about needing work on 3 water treatment plants, and water bills are literally expected to double as a result of the need to upgrade this infrastructure. It's going to happen everywhere. So make sure that you are able to recover utility bills if you're legally allowed to, and share that accountability with your tenants now for your own profitability as well as the good of the environment. So, oops. And how does RUBS work? We use an algorithm to allocate bills fairly. We can provide up to 90% recovery for water, trash, hot water, electricity or gas where it's allowed by law, things like landscaping and pest control that maybe you want to share among your tenants. If we're talking about gas and electricity, it's a simple square footage formula. People pay by the size of the unit. We use allocation formulas for things like water, hot water, sewage, and trash, which include the number of occupants. And you see it's not a straight 1-to-1 ratio. If you have 2 people, they don't pay twice what one person does. You can see that right here on the table. We also consider common area and in-unit amenities. So if you want to, if your multi-unit building has a small lobby and you want to allocate that cost among your residents, you can. If you want to, depending on the law, of course, if you want to take that expense on as the housing provider and remove that from the common bill, you can do that too. We allow for incredible flexibility and transparency in allocation, which helps residents understand the fairness of how this all works. With the right ratio utility billing platform, you will be able to review those month-over-month utility costs and how much you've recovered. You'll give tenants an online portal, and you can see right here, this is actually the property manager portal that's on the screen right now, but you'll have a resident portal and a property manager portal. We have a calculator available to help you tell prospective tenants their average bill amount, which will then also help you set market rent. You'll be able to view your allocation tables, occupancy lists, enrolled unit data, and payment performance, which is very important. And it'll also help you manage turnover and occupancy changes. Tenants can let you know when they want to move out, and then we can set the end billing date based on that information. Now, legal requirements. John, you're on mute.
I kept reminding myself, I'm like, I'm going to forget. And I did.
It happens to everybody.
So this is my deal, talking about the legal requirements here. So the first and foremost is some of you out there are probably in states or cities where there are clear laws that say exactly how to do it. I know that our friends in Texas have a law that specifically outlines how you can pass through utility costs to residents in a landlord-tenant relationship. However, a large amount of the country and even a large amount of the state of California, even though there are regulations for certain cities, overall the law is silent on exactly how you're allowed to do this. And where it's silent, it, it backs up to contract law generally. And in contract law, what you need to have is a clear and understandable basis for any charges that are going to your residents. So that's why transparency is up top, bolded, first thing on my list, because if you're going to be charging somebody, you have to know, or you have to let them know exactly what's being charged and how you're coming up with that charge. Now, it doesn't have to include the the actual bill being attached to every single thing. It just has to explain in a way that's understandable how the number is being derived, which comes to item number 2, which is the actual contract. That's your lease addendum. You want it written, you want it at the outset of your tenancy to say exactly what's being billed and how. So you're going to disclose that methodology. And that's what Annette was talking about when she was explaining RUBS, whether it's a per occupant allocation or whether it's a square footage occupation, is how are you taking that master meter, that single meter for the building, how are you taking that bill and separating it amongst, one other or 2 units in a duplex or 60 units in a larger multifamily building where you've got a range of 1 bedroom, 2 bedroom, 3 bedroom, and any number of different occupant levels. What also you need in that addendum is that your tenant is signing a document that says, yes, I am paying for this amount that you just told me you're calculating. And it doesn't matter how you're doing it, but you need to have the tenant agree, or you need to be able to legally place that requirement on a tenant. I'll get into that a little bit later about how you can do this after the tenancy started. But when you're starting your tenancy, you want to make sure you have a lease addendum that says, tenant, you're paying for a portion of the utilities that are charged to the building. Finally, you want to identify, are there any additional fees? Are you passing through a billing company's fees? Are you charging fees for your time in actually going through and doing the allocations? There are some companies that do all of this for you. They do the allocation. That obviously Livable, the sponsor of this, they have multiple products that allow you to do this, and they'll, of course, there will be a fee for that. Deductions, you want to make sure that you're saying that, are you taking out a common area deduction? So do you have landscaping that is for a park-like area, or is there an outdoor space? Is there a pool? Those are the types of things that if you are charging a per unit utility pass through, to decide whether are you going to include the fact that you heat your pool, for example. All right. So that takes care of the lease addendum. Now, this is kind of an even before leasing issue here at the bottom. It's that you need to make sure that you are consistently informing people exactly how this is happening and that it is happening. So you want your advertisements to say, it's rent plus utilities. You can even, protect yourself more from any claims of misrepresentation by saying it is rent plus allocated utilities or RUBS utilities or any other type of iteration of how to explain and make sure that everyone is on the same page that these costs are being passed through. So those are the points that you want to make sure you're taking care of when you're implementing this, if you're running this already, and you want to make sure that you're most protected from any kind of claims that you're not able to pass through those amounts. So of course there are limitations. The first one is that this cannot be a profit center. RUBS needs to be a pass through of costs that you're actually having. So I will qualify that the administrative fees are separate from what's being passed through. And the question of, can you charge administrative fees? And is that going to be part of the utility cost that's being passed through? That's something that you want to address with your local council and with your billing provider to know exactly what you're able to do. And the reason for this, not bumping it up for a profit is that there are both state and local laws here in California and other places that state that you can pass through cost of utilities, but it has to be at the same rate as if the resident was getting it directly from the utility provider. And it's also just a good rule of thumb because what would happen, or the concern, is that if you are, for example, water, if you are charging residents more for the water than you are receiving, it's possible that your jurisdiction may then deem you to be a utility because you are charging people for the water that you're providing through your pipes. And being deemed a utility then means you've got all kinds of other regulations that you're probably not ready for, water quality testing and making sure that, or probably, at least in California, then requiring to have actual meters and weights and measures and all of those things. So again, it's just passing through what you're being charged, not a problem. If you are trying to charge more than what you're charged for it, that's when you could have an issue. All right, I want to get back to the fees. Yes, you can charge them, but they need to actually relate to the cost of what you're charging them for. You need to be able to point to something and say, okay, my billing provider is charging me this fee to run this, so that's why I'm passing that fee through. Or you say, my employee, it takes them an extra 2 hours to go through and do all of this. That equals out to $2 for each unit I have to be passed through. That's what reasonable and defensive fees mean. Now, I know this next bullet is more of an issue here in California than a large majority of the country. And it's becoming more of an issue in some of the California adjacent states. We've got Oregon and Portland with its interesting regulations, and the state of Washington and Seattle are getting close, but not quite there. And obviously, you have New York and New York City with its regulations. The problem with rent control laws and utility pass-throughs is that you have to look closely at what the different definitions are of rent and whether there are any specific billing methods that are mentioned in that law. For example, most definitions of rent here in California in different city rent controls say any amounts paid to the landlord for utilities. Obviously, if you're master metered client and your property only has that single meter and you're passing that amount through, then that is deemed rent. Now, there are ways to create an addendum to fit within those types of rules, but again, it's going to depend on what jurisdiction, how to be able to do it, whether it will work in the, work in the end. And so again, you're going to want to talk to local counsel, talk to your billing provider about what's going to be available in rent control jurisdictions. Now, one of the trends here in California is that individual cities are implementing different rules. So either they are implementing rent control as a new law, or they have rent control and they're modifying it. So as an example, the city of Mountain View, they introduced rent control. It was like no, it was longer than that. Time goes by too quickly. I have 2 kids and I forget. So it's like 7 years or so. But when they first rolled rent control out, they didn't define whether utilities under RUBS was going to be an issue. Now, myself as a lawyer looking at the law, I would say, yeah, it was part of rent, it fit within that definition. However, the city allowed landlords to continue using RUBS and to address that as a utility that was separate from rent rather than part of rent. The other idea is that you're able to say, well, I'm going to include RUBS as part of rent, but the way that I'm going to use it is to call it a discount. So residents, your rent is this much, and then RUBS is going to be on top of that with a maximum of this much. And if you conserve, then you can discount it, and that's how it'll fluctuate under the maximum rent that's been set at the outset of tenancy. And I know this is all real legal nerd stuff, but it's just showing you that there are ways to continue to use RUBS even in a highly regulated arena. The problem with Mountain View is that this past year, the city decided that RUBS was just out the door. And so they introduced and passed a new ordinance that specifically said you cannot use RUBS. And it wasn't, it wasn't a limit on the rent. It wasn't a limit on what you're able to pass through. It was just you cannot use this method. And the only silver-ish lining was that any landlord who had started using RUBS was able to have, or will be able to have, because this is ongoing, a one-time rent increase for their base rent to make up for the fact that they're losing the ability to charge the RUBS that they have been charging over a number of years. And this is also a similar case in places like Pasadena and otherwise. But the other point is when you're in a non-controlled jurisdiction that is going controlled, is that if you already have RUBS in place, then you already have a basis to say this is what the total rent is going forward, and you're not going to lose the idea of your base rent being lower than it should be, and you losing that RUBS cost recovery at the same time. And finally, you've got enforceability. Enforceability goes back to kind of what I was talking about with those contract provisions and the transparency and so forth. Because the issue is, if you have a statement in your lease that just says tenant owes landlord utilities, and then you put a utility allocation program in place, the tenant has no idea what that means. And so when it comes down to it, to enforce it, because you have two options of enforcement, you can either enforce this as a breach of the lease. You haven't paid, as a lease requirement, so you've breached that lease. We can take you to housing court or eviction court, UD, whatever it's called in your jurisdiction, and have that person out for failing to meet the requirements of the lease. The issue, though, is that if you have that just blanket statement, tenant pays for utilities, court's going to say that's too vague or that's ambiguous. And because, we're the big bad landlords and we do nothing but hurt people, even though we're providing housing and making sure that it runs and making sure everything's perfect and fixing everything for the people that live there, we're still the bad guys in a lot of courts' eyes. And so the kind of general legal aspect of that is the person with the higher bargaining power is usually who a contract is interpreted against. So if it's incredibly vague or even just not clear enough, the court is going to say, well, there's no way this tenant can figure out how they're being charged for something. And so that means that part of the lease is not enforceable and you have to pay back everything. Oh, I forgot that I had a whole slide on this.
Luckily, I didn't.
That's good. That's, you're having communications. I'm just supposed to
Teamwork.
know the law stuff.
Teamwork.
That's right. But yes, so this goes perfectly with the end of that, with the limitations on what you can enforce and can't. So, like I was saying, the first part is you can enforce the lease terms, and that's the whole service of notice to pay or perform. Again, and that's going to depend on your jurisdiction and whether RUBS is deemed rent where you are. And in California, we like to say it's best to use notice to perform or quit because it's a lease term. We don't want it to be considered part of rent. And like most jurisdictions, if you are off by dollars in your notice to pay or quit, then you get bumped out of court and you have to refile. Also, honor the lease terms. And Annette, let me know if I have jumped over something, because
No, I think you're good.
So the other part of enforcing the lease terms is that if somebody moves out and they've not been paying your clear, understandable lease addendum supported utility fees or pass through, then you're able to withhold that from the security deposit and hopefully cover it. But if not, then you'd be able to go after them under the contract terms. So, here's the other legal nerd thing is that when you have a lease or a rental agreement, it is both an estate in land and a contract. And that's why we've got the two separate here, because when you've got an estate and land and it's a tenancy, then you've created these other responsibilities and rights of tenants. And that's why you go to your unlawful detainer or your eviction court on those types of issues. But a lease rental agreement, it's also a contract. It's a business agreement. I agree to do one thing in exchange for another. And because of that, that means you don't have to go to eviction court. You don't have to file that unlawful detainer if someone's not paying. You can go and try and enforce your contract rights, depending on the amount that's owed. You can take it to a small claims court. You don't need to get your lawyers involved at that point. This can be during the tenancy or after the tenancy. Usually, I would expect this would be a post-tenancy after move out non-payment issue is something that you can take to small claims court or assign it to a third-party collection agency. Because again, you've got the contract, and as long as it meets everything that we've talked about, that I've gone on and on and on about, then it's something that you can assign and have someone else do the collecting for you if it's, worth your while at that point.
Yeah,
With that,
I'd like to remind everybody that you are going to be sent the recording and the slide deck, so you don't have to worry. I've gotten a few questions about, can you repeat that? Can you tell me what to do if they don't pay? We're going to send all that information out, so you're going to get this in multiple formats. Because I know it's a lot.
it is a lot, and I could continue on and on and on, but I don't think there's another slide except for we can start answering questions.
Okay, let's see. So I just want to talk very quickly. We've gone over all of the big information here, the really educational part. I just want to talk very quickly about, well, actually, no, before we get into about Livable, Alexandra, can you do the poll question, please?
Yes, absolutely. So we did want to know of you on the call today, how many of you are including utilities with rent already? So very curious to see, because I know Annette and I were just talking about this before. If you're here to learn about this topic, I'm sure there's quite a few of you who are probably not
Right.
doing it yet, and then others who might be doing it, but like in a very manual sort of way where, we can find some better ways to do it more efficiently and also more legally so that you don't get in trouble. This is interesting. I'm seeing the results as they come in. I know Annette and John, you can't see that, but it is pretty split, like 50
Really?
50
Okay.
right now. So like I'm waiting for just a few more of you to enter in your question or your responses here to the poll, and then we're going to go to questions in just a second. So I'm going to leave that up for just a tad longer. I know, Annette, I saw you answer a few questions in the Q&A. Thank you for
Yep.
doing that. Were there any that you answered so far that you'd like to mention that are worth bringing up for the rest of the group?
No, not so far. I'm
Okay.
seeing a couple more come in, so let me just take a look. Okay, yeah, so most of these questions were more, so one, we were talking about rent control. So somebody did ask about Pasadena. Pasadena just started a rent control law that kicked in January of this year. And Pasadena's law specifically cites that you cannot do ratio utility billing if the amount of the billing exceeds what the legally allowed rent increase is. So check with your local attorney. Did I get that right, John? You want them to check with your local attorney. If you are a multifamily owner, if you are a housing provider in Pasadena, check with your attorney before embarking on any kind of ratio utility billing program, because you want to make sure that you're getting your money in the best possible way. So I did want to bring that up. We did talk about California and rent control laws and some of the specifics there. Um, then let's see here. Yeah, the rest of these were a bit more
Okay,
specific, so that's all good.
great.
We have had a bunch of questions come in right now. Okay, and so we're seeing that 55% of you don't include utilities with rent now. So, okay,
So
all
you're
right.
you're in the right place, basically.
Yes, 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 yes.
I saw someone else ask if we can get that utility billing addendum, and we actually have Livable's addendum on our website under our free forms. If you guys go to the chat box, you'll see it at the bottom or top of your screen. I just dropped a link in there. If you click there, it'll get you straight over where you can download the form for free. It has some instructions and disclaimers on there, but it is a great place to get started. And then if you did have any specific questions about that addendum, you could always reach out to Livable on that. And then I'll let Annette, you were going to talk a little bit more about Livable to close up here.
Yes.
So let's do that first, and then we'll wait for some more questions to come in the meantime.
Okay, yes. All right. We did just get a question. Um, where did it go? Because I answered it, so it moved. Okay, so I did just get a question about if we don't have rent control, can we use allocation or square footage formula? That depends on the utility. Square footage is used for electricity and gas. Allocation, which includes things like, it does include square footage, but it also includes occupancy. It includes in-unit amenities. If you've got one unit that has a dishwasher and one that doesn't, maybe you want to bill the water a little bit differently for those two units. If you've got one unit that has a washer and dryer and one that doesn't, they're not using the same amount of water. So you want to consider all of those things in that allocation formula so that it's not an either or based on your local law. They're used differently for the different utilities, and which utilities you're allowed to bill for do depend on your local law. A lot of places allow ratio utility billing for things like water, trash, and sewer, but not for gas or electricity. So it really does depend on what your local laws are. So I wanted to just get that one answered because I'm sure that more people. So there's somebody who's asking about a law in Houston, Texas. Check with your local attorney. I don't know what the statute in Houston is. And then, yeah, Cerritos, California, same thing. Please check with your local attorneys to see what what you're allowed to do. That's the best overall answer for everything. Um, let's see here. Okay. And then the link is in the chat. The link to the addendum, she put Alexandra put that in the chat. So it's not in the Q&A, it's in the chat. I got a few questions. I can't see the link. I can't see the link because it's in the chat. It's not in Q&A. So
Yeah.
different location. Okay, so Livable has been around since 2009, founded by multifamily owners and operators in San Francisco. And conservation really is a key part of our mission. The other part of that is bringing enterprise level tools to independent rental owners. The kind of tools for ratio utility billing have existed for large property owners for a very long time. But you had to have a minimum number of units. Maybe they wanted 50 units or 100 units before you could even enroll in the program. Livable is really meant for the independent rental owner. Although we do serve massive communities, we also will serve your duplex or your triplex or your 10-unit garden apartment building. Whatever your need is, we can do that for you. If you have a single family home where you want to just make sure that that bill is coming through in a different way, where both you and the resident are seeing it, we can help you with that. We work with solar. I am not an expert on what we do with solar, but I know that we do have solutions for solar. So it is really about conservation and about helping investors get the most out of their rental properties. We do have more than 80 team members distributed throughout the US. Most of us work remotely. And our headquarters is in California. So that's one reason we have a California attorney here to help us today. And we have a better understanding of the laws in California because that is where a lot of our business is. So, um, so we do customizable billing. We do have a multilingual tenant support team. We are working on eventually translating the tenant portal into different languages so that it is easier for residents, no matter where you are, no matter where they are. And we do have an excellent customer service team. I'm going to keep answering some questions, just leave a few client referrals up here, and let's see what else is in the Q&A. So yes, so
And
Santa
then
Clara.
yeah, I was just gonna say, I noticed a few that I could
Yeah, John,
answer
please jump in.
quickly here. So, uh, I did hear you start to say Santa Clara. I did see that question, the question of whether you're able to summarize the question is whether you can implement RUBS to a month-to-month tenant. Here in California, as long as they are month to month, you can implement RUBS through a notice and change in terms, as again, as long as you've met all the rest of everything, you've got a good addendum to put in place and you follow the rules of noticing that change in terms, you can implement RUBS during a tenancy. Again, if it's month to month in California, if you're in the middle of a lease term, your tenant is going to need to sign a new document. There was a question about, you talked about an addendum. What if I already have this in my lease? Addendum, lease, it's really the same thing. It just depends on how you like to structure your documents. If your lease has all the information that I discussed about needing in an addendum, then you're all set. There's no need for a separate addendum document, as long as, again, transparency, specificity, then you're fine. I do want to answer a question about, surely there's a general resource for summarizing local ordinances. You would think so. The problem
No.
is that everything changes so often that it is practically impossible to keep that up without at least an individual who is full-time 40
Yep.
hours a week keeping that updated. I know because during the pandemic, I was keeping an updated database of just local pandemic related restrictions. And I could barely do any other work for clients because it took so much time just to keep an eye on what those localities are doing. Because once a local jurisdiction does something, it doesn't get just published to the world. It gets published in this tiny website that is publishes ordinances, and each city uses a different service to do this. There are some cities that all use one service, but that still doesn't make it any easier. And I'm sorry, that was my tangent rant about local restrictions, because it obviously affected me.
Yeah, I mean, we also struggle with that, right? Because we're always trying to keep all of you informed here at AAOA, and it is tough to keep up, but we do our best. So, a couple of questions that I saw that were kind of interesting as well is this one that I think we talked about it before the call a little bit, but it was about a duplex. And if you have a duplex with just the one water meter, is it okay to appropriate that water bill based on the number of individuals? And there's a lot of questions as well as to whether it's by individual or by unit. I know we touched on it lightly, but maybe we can go back and kind of give a little more detail to that.
Yeah, and that's what Livable Pro is actually designed for, is the independent rental owner small rental owners who don't have massive complexes that they need to build for. I'm seeing, is it based on adults or occupants? It's occupants. It's the number of people. But we don't figure, adults versus children. It's just the number of people who live in the unit. But you can allocate based on the square footage, the occupancy, the amenities in the unit, and absolutely you can share you can allocate the costs of a master water meter for a duplex, a triplex, whatever. Yes, if you have a small multi-unit building, you can add one unit at a time as residents turn over. Resident turnover is an ideal time to implement RUBS if your local jurisdictions allow it. Lease renewal is another great time to do it. A lot of places allow it, but not in the middle of a lease. So lease renewal or lease turnover is the ideal time to bring each unit onto a ratio utility billing platform.
Yeah, and that kind of goes into another question that I've seen here that is asking, am I able to do this one unit at a time? And the answer is yes, because again, it's a contract that you have with each individual tenant. So the tenant is agreeing that they will pay the amount allocated to their unit, and knowing that that allocation is an estimation, but it's a calculation that takes into account all the things that are expressed in your RUBS addendum or in your lease addressing utilities. So it is something that you can roll out slowly in a property. That's something that you want to do in rent control jurisdictions because you're able to set the initial rent. And again, in California rent control jurisdictions, because you can set the initial rent, and that way you can say that that RUBS pass through as part of that initial rent, and you can do that as the building slowly turns over.
Yep.
Let's see, I thought there was something else.
I saw one that two people had now in the chat. Tabitha, we have shared laundry in a common area that people pay to use. How would this be figured into RUBS? And Dan has the same question as well.
So my immediate take on that, and John, I'm going to let you correct me, is that if they're already paying for it, then if you add that into RUBS, you're basically double billing them. And I don't know if that would count as fair and defensible. If they're already paying to use the machines.
Right. And just to add to that, that's what we were talking about way earlier when we were talking about deductions and fees. So if it is something that's in the common area, and as Annette said, if it's being paid for separately, then that's something that you want to show the tenants that you are considering, and that in fact you're deducting a overall percentage of the master total bill for the property in order to take that into account. So you're saying, look, we know we have central laundry. That's part of why our common area deduction is the term used in commercial contracts.
Yep.
And that's just to say, okay, we agree, we landlord or me landlord agree that 10% of the water bill is for the laundry. And so I'm going to take 10% right off the top of that bill before it gets allocated to residents.
Right.
Right.
Right. And that sort of thinking would also apply to things, and John mentioned this, like a sprinkler system. If you have a sprinkler system that is, watering the lawn around the property so that it looks nice, you could potentially share some of that cost among your residents. You might also simply look at it as part of your investment in upkeeping your curb appeal.
Yeah, absolutely. That's important too. And I also want to say as well, if you're listening to this and you're just like, I don't know, like what percentage or what amounts or need to go where, Livable can consult with you and give you an
Yes.
idea of like exactly how to break that up so that, you're comfortable with it and it also makes sense for the tenants that you have. So, I just know the resource is there. It's
Yep.
free to talk to them and they'll give you a head start on exactly what to do for your specific kind of setup that you have, whether you have the laundry, common areas, or
Yes.
whatever kind of building or rental you have. I mean, it really doesn't matter. So
Yep.
you can get, their advice on it.
Yeah,
Um,
we have a robust calculator on our
mm,
website that will help you get an idea of how much you can recover. You are more than welcome, and I know that AAOA will very generously send out the information tomorrow with my colleague Dean's. Dean is not on camera, but he is with us today. My colleague Dean's contact information so that you can book a call with him. He will walk you through how Livable can help you. Obviously, at no cost and no obligation. I'd also like to throw out that AAOA members, so everybody on this call, can use a special discount code to get 3 months of Livable Pro free. So 3 months that will let you see at no cost, no obligation, no contract, no unit minimums, how this can work for you.
Great. We'll put that code in the email as well.
Yes.
And I
Yes.
also saw someone mention that they had a hard time opening up the addendum in the link that I provided. So I'm going to provide it as an attachment in the email tomorrow as well. So you guys can get that. So please look out for that email. That's going to be crucial for you guys to really, get the most out of this. And John, thanks for putting that resource for Texas in the chat. I know we have quite a few in Texas rental owners
Awesome.
in the meeting. So thank you for doing that. A question that I had as well, and I saw come up prior to this webinar was if you can charge Section 8 tenants for RUBS or if that's any different.
You can. Again, it depends on local ordinances, but as a general principle, yes, you can.
And then another question I saw as well was whether you should put the utilities in the renter's name or in your own name. How do most livable clients handle that?
So it's a master build utility. So the master build utility is always going to be in your name. But
Mhm.
through Livable, each of your residents has their own account, their own login, their own dashboard, their own ability to pay. They can do, credit or debit card. They can do ACH transfer. They can pay you directly, and you can update the ledger if that's easier for how your investment business works. But the master utility, you still pay your utility bill. So you would still pay your building ABC water bill every month, but then you pull that bill into Livable system. The allocation formula gets run. Your residents get sent the bill, they pay it, and then we pay you.
Mm, okay.
So
So
that's how
that
that works. You're not taking anything out of your name. You're simply billing your residents for their share of the use after you get the bill.
got it. Okay. Thanks for clarifying that. Svetlana and Janet had a similar question here. Svetlana is saying that the tenants have agreed to pay for water for the garden and water for the family in a single family home. It's in the lease agreement, but then suddenly they don't pay it or they don't want to. And then Janet was asking as well if that would go on their credit report or what would be the consequence in that case if they aren't paying the bill.
So Livable is not currently working with credit reporting agencies, but if somebody did not pay the bill, then um, you could put that through a debt collection service, which then would impact their credit report.
Hmm.
So
Okay.
if they're not paying the bill, you can absolutely go through a collection agency, and then that will impact their credit. You take them to small claims court, it's going to impact their credit.
And in California, at least, we usually recommend to clients, to landlord clients, that if you want to report, then you need to have a disclosure in your documentation that says you're
Agreed.
going to be able to do that. And so that's
Agreed.
really going to determine whether or not you're able to do that. Also, it's something where, as Annette was mentioning, there are specific, reporters of credit, and that is going to be probably your most effective way of actually affecting that resident's credit if they are in that much default that you feel that that is necessary to do. I do want to answer a question here that is California specific. Somebody is saying that AB 1482, which is California's statewide rent control, so that applies to all properties in the state, all multifamily properties in the state that are older than 15 years. And there are options of how to handle that in terms of RUBS. The most conservative way is to have the rent cap include a cap for utilities costs as well, and to provide a discount from that cap. In the addendum that is provided, it's called a not to exceed amount. And that way, if somebody is to claim that they shouldn't be paying that amount, that it is an illegal increase, that you're increasing rent above the limitation, then you're able to say, look, you've signed a lease with this with this addendum. It shows you exactly how this is going to be charged. There's a cap so that there is no increase over the maximum. It is not entirely clear in the statute what is supposed to be included for rent. That just means that you can get creative after you've talked to your attorney. Do not just go, oh, well, some guy on the internet told me I could do something different. So that's just a one general way of handling it. Otherwise, talk to your attorney about what you're able to do specifically at your property. And that also goes to the question about if you already have something in your lease that says tenants agree to share utilities, can I change to a RUB system? That is going to depend very heavily on what is actually happening at your property. So reach out to somebody and have that conversation either with an attorney or with Livable, who's offered to have those kind of consult conversations.
Great.
Okay.
So I'm looking over. I know, Annette, you've been going real fast on answering some of those questions. Thank you for doing that. I think we've answered, but it says 41 questions. Amazing. So I have about 29 more
I type
questions
fast.
left.
I type fast.
It's clearly, we have 29 more questions left here. So let me see if we have any that we haven't covered. Let me see here. Oh, well, this one's kind of interesting. Annette, you might be able to answer this. If there's any sort of RUBS billing options with any property management softwares, if you guys are working on any integrations with any platforms that our members might already be using to manage their rentals.
We are indeed working
Ooh.
on some of that. I cannot talk about it right now. But we are working on integration with a very major property management platform that hopefully will be launching in September. So stay tuned. Believe me, there will be an announcement. But I can't talk about it yet.
Amazing. Okay, well, keep an eye out for that coming soon. That is very exciting. I love hearing that. That should make it even easier for you all if you're using that software. Okay. And also another question that came up, I don't know if this is a thing, but John from California asked, can you ask for a utility deposit in the lease agreement? Have you ever heard of that?
Well, the problem in California is that uh, I'm sure you're aware we've had recent changes in the security deposit law. The issue is not what you call it, but what you're doing with it. Anything that you're taking as a deposit, if it's on pets, if it's, you know, the security deposit, if it's a utility deposit, all of those deposits are the legal term of a surety. It's held by the landlord in order to pay for any kind of default in the lease or any damage caused to the property. And that is now capped by the recent changes to, and I can't recall if it's gone into effect or is about to go into effect, to the 1 month of rent. And so you can include what you call a utility deposit as long as when added to your security deposit, it doesn't go over that maximum.
Yes, and that law goes into effect July 1st of this year. So in a few weeks, 2 weeks, you will no longer be able to collect 2 months security deposit in California. So
In Florida, you can do anything.
I know, right?
You can do absolutely anything in Florida. It's the Wild West down here.
Yeah. Yeah, 1 month, it just seems so limited. Gosh, I mean, you're right. I mean, no matter how you split it, it's still not a lot of money. So, it's gonna definitely be tough to adjust to that. And I think that really just means we're gonna have to be more cautious of the types of tenants that we let into our units. And we'll definitely have some follow-up webinars on that topic. Okay, I'm trying to see if there's anything we haven't covered. I know some of these questions that were submitted before the webinar came in, we've now covered during the webinar. So I'm trying to go through and see if there's anything here that we haven't addressed yet. I think Daniel, he asked here if there's a max admin fee. He has rentals in California, Texas, and Oklahoma. But it seems like that's more jurisdiction based for the admin fee.
Right. Again, the idea is that it needs to be related to something. It can't just be, well, I want to make $20 more a unit, so it's going to be $20. It has to be either I'm paying a service, and so I'm passing that through, or I'm doing it myself, and these are the extra costs that it costs me. And there are uh, specific rules in different jurisdictions about those admin fees. If I'm remembering correctly, the Texas law specifically limits or provides an amount that can be accepted as an admin fee. If you're in a place like Los Angeles, Los Angeles specifically says you cannot collect an admin fee for water. And so, or electricity, it's a weird Department of Water and Electricity there. So um, that that is something that you want to explore for every spot that you've got one of those properties.
Okay. Um, I think we've covered everything. I was trying to go through those other questions, and honestly, you all have been so thorough that I think any questions anyone had here that we haven't addressed are very specific. Like, I'm seeing questions like, I have a commercial building and it has this many people, and we have this much and so those might be a little so specific that that's where you're going to want to contact the Livable team. And then the other questions I feel have been pretty well answered. And so if any of you arrived late to this, I do encourage you to watch the recording, which we will be sending out to you tomorrow with the slides. We definitely went over so much information today. It's worth watching again, especially if you are, ready to start charging for utilities or you want to automate the process a little better. Um, with that said, though, Annette, were there any other questions that you saw that you'd like to bring up or any final comments?
Um, no, I think that we are pretty good. A lot of these, the answer is check with your attorney. Seriously, check with your local attorney. Um, I'm seeing some very specific kinds of cases that
Same, yeah, they're just getting more and more specific now as we've gone
yeah,
further and further in.
way out of my wheelhouse. I'm just a writer, folks. I'm just a
Yeah.
writer.
Well, a
I
good one
will.
at that.
Yeah.
Um, but
And a bit of an expert on this at this point, but no, a lot of these very specific case questions, absolutely, you need to speak to your local attorney.
great. Well, there's lots of thank yous in the chat and Q&A. And so is the city attorney is good for the questions?
No,
Is what
your
Lauren said.
attorney,
Your attorney,
your
pick a good
attorney.
attorney. For those of you who don't know, on AAOA's website, we do have a chat with an attorney feature. I can show you guys where that is if you do want to plug in a question. It is just online kind of chat, but it could be potentially a good place for you to go. If you go to our website, if you don't mind, I can sort of show you guys. I'll take over the screen sharing just before
Yes, let me just
we
turn that
head
off.
out here. I just want to show you this because here it is. Okay. So if you see here on our website, I'll wait for it to load. We have here, I have this pulled up. This is the link to the utility addendum. But if you go to solutions in our menu and you click legal help, this will take you to a place to enter in a question here that an attorney in your area can answer. And it is $5 for the first week that you give it a try. And then after that, it's $53 a month, which is very affordable.
Oh,
I've used
yeah,
this service before, and they're usually like retired attorneys that do this, and
that's
they are
awesome.
very thorough. And it's just online. So you
Yeah,
ask a question and they respond, and you can ask as many questions as you want, and they get back to you pretty quickly. So that is really a great resource. So again, go to our website, solutions and legal help. I will also put this in the follow-up email. And then where I got the forms is under forms. And then you can either go to forms and free, because this is a free form we offer for everyone. And then here is the list of all of our free forms, and the ratio utility billing addendum is here. We also have some other great forms that you can check out as well. So definitely encourage you to do that. If you didn't know about those resources already, I'll be putting them in the email again with everything else. And I think, really, we've done so much work here in the last hour or so. So thank you so much to Annette and John and Dean in the background, who is going to be getting back to you all with very specific answers for those
yes.
specific questions. So please give us a day or two to get back to you if you didn't get your question answered. But watch out for that email tomorrow. And I really, thank you guys both for being on this webinar and being just
You're
so
very
thorough and
welcome.
generous with your time.
Well, thank you for having us. We appreciate it.
Of course. All
Thank
right,
you.
everyone. Have a wonderful day. We'll
All
be
right,
in touch
thank you.
soon.
All right,
Thank
bye-bye.
Bye.
you. Bye bye.
Thank you guys.